So how far do we go with this? You can still be president if you straight up murder someone? I mean, on paper, yeah. On paper, you can murder someone, be arrested, charged, convicted, and if an election happens before your sentencing, that's what this means on paper. Yeah, it's the Fifth Avenue thing manifest in real life, in actual policy. Yeah.
This day.
Good morning, everyone. I'm Kira Phillips. We are coming on the air because President-elect Donald Trump has just been sentenced for his conviction in the criminal hush.
Officially a convicted felon. Now, I didn't realize this, but it's not necessarily official until you're sentenced. Once you're sentenced, you are officially convicted. So as of today, Donald Trump is officially a convicted felon.
Money case in New York, making him the first American president to be sentenced for a crime. This comes just 10 days before he takes the oath of office. Now he will return to the White House as a convicted felon. Let's get straight to our senior investigative correspondent, Aaron Katursky, outside the courthouse in Lower.
He asked the Supreme Court to delay the sentencing, and that was actually a close decision. It was a 5-4 decision. Amy Coney Barrett joined the liberals, and who was the other conservative that joined the liberals? I'm guessing Roberts. Was it Roberts and Amy Coney Barrett? Yeah, he actually got kind of close to getting that delayed.
Manhattan. Aaron, Trump fought to the bitter end to prevent this sentencing from happening. He hoped the Supreme Court would save him too. Clearly that didn't happen. You were in the courtroom. How powerful were Judge Merchan's words to Trump?
He sentenced Trump to an unconditional discharge as he promised he would. He said it was the only lawful sentence he could impose to respect both the sanctity of the jury's verdict convicting Trump of 34 felony counts of falsifying business records, and also the duties of president that Trump is.
Do we have a transcript of what Merchan said?
About to undertake. But Kira, he took pains to tell Trump that he was treated like any other criminal defendant.
Listen to audio of Judge Merchan's sentence of Trump in hush money case. Listen to the audio here. Can you guys hear the audio?
In this case, as you know, stands convicted of 34 counts of falsifying business records in the first degree, all Class E felonies. Each carries a range of authorized sentencing options for as much as 1 1/3 to 4 years in state prison to a variety of non-incarceratory sentences. In this court's January 3rd decision on the defendant's Clayton motion, Your Honor indicated an inclination to impose an unconditional discharge. Under all the circumstances of this case, its unique posture and the defendant's status as president-elect, the people recommend a sentence of an unconditional discharge. In finding the defendant guilty in this case, the jury necessarily found unanimously that the defendant falsified 34 separate entries in his business records with the intent to defraud, which included an intent to commit or conceal a conspiracy to promote his own election by unlawful means. Having presided over the trial, Your Honor is very familiar with the conduct, its seriousness, and the overwhelming evidence to support the jury's verdict.
Squeaky duck quack, what's up, buddy?
In last week's decision on January 3rd, this court referred to the gravamen of the defendant's conduct, his criminal conduct in this case, as constituting, quote, premeditated and continuous deception. The verdict was delivered by a jury that was carefully chosen using an extensive...
My voice is a little bit, yeah, I wore a mask when I went outdoors yesterday, so like I feel fine. Like I didn't spend a lot of time outdoors. Outdoors is it's just really bad. In Los Angeles, it is a hellscape. You cannot see the sky. It's just nothing but brown smoke. It's really, really, really bad down here. And to make matters worse, I mean, look, I'm going to sound ungrateful. Like, it could have been really bad. Like, my home could have burned down. I mean, we're very, very close to the fires. My home could have burned down and it would have just been a nightmare. And so I'm very grateful that didn't happen. A lot of people are suffering right now. Thousands of people, I think, have lost their homes. But, we got another false alarm. So what happened was yesterday during the day, we got this really loud notification on the phone, like the phone starts going, bah, 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 and then you look down and it says, you've been ordered to evacuate, your area is affected. And my heart just went like, just dropped into my stomach like, bro. And then we looked into it, and it turns out somebody sent a county-wide alert. It was a mistake. LA County has, I think, 20 million people. Like, the big up. And it happened again at 3:40 in the morning. I was awoken to the same noise coming from my phone. I'm like, woke up out of deep REM sleep, and I'm looking at the phone like, what the f is going on? And it turned out it was another mistake, and it happened again at like 4:30. So my sleep got so f***ed up last night. Again, not to sound ungrateful, there's a lot of people that are like really suffering right now. So minor inconvenience, but man, what is going on? Who is in charge of these alerts?
Any
in Los
alerts about
Angeles?
ICBMs?
Not to my knowledge. There were no alerts of any ICBM threats. No.
Extensive questionnaire based on suggestions from both parties and after thorough questioning of the prospective jurors by both sides. The verdict in this case was unanimous and decisive, and it must be respected. As this court has observed, quote, the sanctity of a jury verdict and the deference.
But the fire that's close to us is still going. 3% containment. The fire that's like, so we're not out of the woods, man. It's like this fire's been going for 3 days now, and it crept up a little bit to the west and like north, a little bit to the east, but it's kind of stayed in the same position for like the last 24 hours. Have any other fires popped up? They were able to deal with the Sunset Fire, which is great. There's another little fires. Yeah, there's like little fires popping up here and there. But it's the Palisades Fire and the Eaton Fire have just been raging for 3 or 4 days. And it's just, yeah, it's the air outside is just so bad. It's so bad. It's so upsetting. Thankfully, like I did have to put Twitter back on my phone for work. Thankfully, I didn't look at like Twitter too much. But the short amount of time that I did look at Twitter and what the conversations were looking like about the fires, it was taking me to some dark places. Because we talked about it on the stream yesterday, but it used to be the case in this country, and it really wasn't even that long ago, that major natural disasters would bring about national unity. The news would highlight volunteers and donation drives. And, you know, for example, in the case of what's going on in California right now, we have planes coming in from Canada. Like, you know, Canadians are offering their services to help California firefighters take control of these fires. And, you know, this is supposed to be something that's really cool about humanity, this instinct, this impulse to selflessly help other people. And then when you look at the social media conversation, it's just, there's like a million new water storage and forest management experts that have just popped up overnight. And they have so many opinions about what's going on. And it's like, dude, maybe if you were here and you just like walked outside and experienced the California climate, you would understand why this fire took place. 80-mile-an-hour winds, 100-mile-per-hour gusts. At times, we're talking hurricane force winds. These are Santa Ana winds. So they're dry and they're hot winds. And then California had another drought this year. And that's all it takes. That's all it takes for fires to just spiral out of control. High winds, warm climate, dry climate, no rain equals fire. And the winds, again, were just, I've never experienced winds like that ever. I thought there was a possibility that our windows were going to blow out. Like I was thinking to myself, I do not trust the structural integrity of these windows. I was fully expecting one of them to blow out. But firefighters that are fighting these fires right now are engaged in bravery on a level that I'll never understand. You know, they're facing down horrendous fires. You know, some of these people working 24 hours in a row. And then you log on and you see people like Don Jr. talking shit about firefighters. So, basically implying that, well, there's too many black lesbian firefighters and that's why they can't get it under control. It's just ugly. It's just gross, So I have to do a bit of triage and make sure I don't spend too much time on social media, because I just feel like people
Hutch,
are fucking
social
scumbags.
media is doom and gloom. But the Red Cross received so many donations and volunteers they had to stop donations temporarily.
That's good.
The Pasadena Humane Society is flush with donations as well.
That's great.
There is rallying in support of fire victims. Stay strong.
No, that's good. I do appreciate that reminder. It's specifically social media that's giving me these dark thoughts, but it's good to recognize that. So, people are stepping up and trying to help out when they can and donate money. And, it's a nightmare what's going on down here right now. It's terrible.
That must be accorded to it is a bedrock principle in our nation's jurisprudence. The defendant's conduct before, during, and after this trial also merits consideration. Instead of preserving, protecting, and defending our constitutionally established system of criminal justice, the defendant, the once and future President of the United States, has engaged in a coordinated campaign to undermine its legitimacy. Far from expressing any kind of remorse for his criminal conduct, the defendant has purposefully bred disdain for our judicial institutions and the rule of law. And he's done this to serve his own ends and to encourage others to reject the jury verdict that he finds so distasteful. He has characterized these proceedings as corrupt, rigged, a witch hunt, or a sham too many times to tabulate. The defendant's rhetoric has only ratcheted up since this court's rulings on his motions to dismiss. He has been unrelenting in his unsubstantiated attacks upon this court and its family, individual prosecutors and their families, the witnesses, the grand jury, the trial jury, and the justice system as a whole. The defendant has not only been held in contempt by other jurists in other matters, but this court alone found the defendant in contempt for 10 distinct violations of the order restricting extrajudicial speech. In his legal filings, the defendant has used dangerous rhetoric in leveling accusations of intentionally unlawful and unconstitutional conduct on the part of this court and the prosecution. As this court has noted, the defendant's conduct, quote, constitutes a direct attack on the rule of law itself. Moreover, the defendant has publicly threatened to retaliate against the prosecutors who have sought to hold him accountable in this and other matters, and the courts who have endeavored to fairly and faithfully adjudicate these matters. Such threats are designed to have a chilling effect, to intimidate those who have the responsibility to enforce our laws, in the hopes that they will ignore the defendant's transgressions because they fear that he is simply too powerful to be subjected to the same rule of law as the rest of us. In his 2024 end-of-year report, United States Supreme Court Chief Justice Roberts warned of the dangers of such conduct. Quote, public officials, too, regrettably, have engaged in recent attempts to intimidate judges. For example, suggesting political bias in the judge's adverse rulings without credible basis for such allegations, end quote. Chief Justice Roberts continued, quote, attempts to intimidate judges for their rulings are inappropriate and should be vigorously opposed. Public officials certainly have a right to criticize the work of the judiciary, but they should be mindful that intemperance in their statements when it comes to judges may prompt dangerous reactions by others. Chief Justice Roberts also spoke of the dangers of disinformation, which are, quote, magnified by social media, which provides a ready channel to instantly spread rumor and false information. Put simply, this defendant has caused enduring damage to public perception of the criminal justice system and has placed officers of the court in harm's way. In the probation report, which we just received this morning, the author, having interviewed the defendant, noted that the defendant sees himself as above the law and won't accept responsibility for his actions. And that's certainly consistent with everything else that we've seen. Now, in a typical case, both the offense conduct and these other exacerbating factors would impact the appropriate sentence. But in this case, we must be respectful of the office of the presidency and mindful of the fact that the defendant will be inaugurated as president in 10 days. Any undischarged portion of a sentence has the potential to interfere with the defendant's performance of the duties of his office. As a practical matter, the most sensible sentence prior to his inauguration is an unconditional discharge. The court has expressed an inclination to do exactly that because, in the court's words, quote, the most viable solution to ensure finality and allow defendant to pursue his appellate options is to proceed to sentence. Now, as you know, in New York, a conditional discharge is authorized by penal law, quote, if the court, having regard to the nature and circumstances of the offense and to the history, character, and condition of the defendant, is of the opinion that neither the public interest nor the ends of justice would be served by a sentence of imprisonment, and that probation supervision is not appropriate. An unconditional discharge is authorized if a conditional discharge is authorized and, quote, if the court is of the opinion that no proper purpose would be served by imposing any condition upon the defendant's release. Because these crimes are felonies, the court must set forth in the record the reasons for its action. The American public has the right to a presidency unencumbered by pending court proceedings or ongoing sentence-related obligations. But imposing this sentence ensures that finality. Sentencing the defendant permits this court to enter judgment, to cement the defendant's status as a convicted felon while he pursues whatever appeals he intends to pursue. And it gives full effect and respect to the jury's verdict while preserving the defense.
I don't love it, but like obviously for obvious reasons, but I understand the DOJ's rationale for why you can't prosecute or now imprison a sitting president. It's just not, you know, I don't think the founders counted on Americans electing a convicted felon to become president, but the policy itself makes sense. I don't like it. I don't like the consequences of this. He was convicted unanimously by a jury. I think he deserves to go to jail, but like it or not, the American voters overrode the jury. That's what happened. And their voice is louder than the jury's.
Defendant's ability to govern. People therefore recommend that this court impose a sentence of an unconditional discharge. Thank you.
Thank you. Counsel.
Thank you, Your Honor. I very much disagree with much of what the government just said about this case, about the legitimacy of what happened in this courtroom during the trial, and about President Trump's conduct fighting this case from before it was indicted, to while it was indicted, to the jury's verdict, and even to.
So how far do we go with this? You can still be president if you straight up murder someone? I mean, on paper, yeah. On paper, you can murder someone, be arrested, charged, convicted, and if an election happens before your sentencing, that's what this means on paper. Yeah, it's the Fifth Avenue thing manifest in real life, in actual policy. Yeah.
To this day. What the government just said presupposes something that we disagree with very much, which was that this was an appropriate case to be brought. It was not. This case, without a doubt, knowing everything we know about the timing of the investigation, the fact that multiple prosecutors looked at the facts of this case, including prosecutors within the district attorney's office in New York County and made a decision not to bring charges. As the court knows,
somebody's in Discord maybe wanting to argue. Do you want to continue listening to the opinion, or do you want me to argue with somebody real quick? Savage Monk?
Hey, what's up, man?
What's up, man? Are you the guy in the YouTube chat?
Yeah. How you doing, man?
We're a little stressed down here in Southern California, but other than that,
How far so far from you?
We're 15 minutes away from one of the bigger fires. Yeah.
Man, that's terrible.
Yeah.
I hope you're doing all right.
We're doing okay. Yeah. I appreciate that. So what did you have something you wanted to argue about?
Not argue. Dude, I'm 38. How old are you?
41.
So when you were a kid, you played football, right?
Not well, but yeah.
And you played Smear the Queer.
That was the game that that was called, yeah.
And you think it's homophobic?
Yeah.
The LBG, the LBGTQ has queer in it.
Yeah.
It's not a game where you try to hurt or you give a gay guy the ball and beat him up. It's a football game. One guy has the ball and everybody tries to tackle you. And they're not trying to kill you. They're just trying to tackle you and get the ball from you and try to score a touchdown. It's not a homophobic game. Why do you think it's a homophobic game?
Well, let me ask you something. Let me ask you something. Are you white? Are you Caucasian?
I'm white. Yeah.
What if I devised a game of with similar rules and I named the game I can't say the slur on Twitch, otherwise I'll get in trouble.
What, cracker? Smear the cracker?
If you could not use those words,
come on, dude, quit being a bitch. Quit being a bitch. Just say the back in the day, people said shit like that.
Okay, you're
40. You're 41 years old. I'm 38.
So
I have.
Okay, hold on. Slow down real quick. Slow down real quick.
Friends of all races. I played sports when I was in high school. I played with blacks, Mexicans, Asians, and we called each other slurs all the time. And when we played sports, we would talk shit to get into your opponent's head. That's how it was back in the day. You're 40. Have you ever played sports?
Yes, but hold on. Before we get to that, I want to explain something to you. If you and I were having a conversation, hold on, let me speak. If you and I were having a conversation outside of a live streaming platform, you could say whatever word you want. I don't care. The reason why I don't use specific words when I'm streaming is that certain platforms have policies that ban those words. Yeah. And if those words are said, my stream could suffer some kind of penalty, such as being suspended for a few days. And I would like for that to not happen. So that's why I choose to not use that language. And that's why I'm asking you to not use that same language as well.
Dude, it's not that bad. Cracker is not a bad word.
Shortly after President Trump announced his intention to run for re-election, this case was started for what amounted to a third time, which brings us ultimately to where we are today. A lot of what the government just said presupposes that this case is legally appropriate and that the charges that were brought by the people were consistent with the laws of New York. Again, we very much disagree with that, and as everybody has been noted, because it's true, we certainly intend on appealing that. And it's not, by the way, just counsel and President Trump that feels that way. There's many, many, many legal experts that share the same views that I just said, which is that legally this case should not have been brought, both based on the facts that were established at trial and also on the legal basis for which they were brought. But it's also not just the legal experts, not just counsel, and not just President Trump, but the majority of the American people also agree that this case should not have been brought. I mean, the interesting thing about the fact that there was a trial for the first time in our history, a criminal trial during an election season, is that the American voters got a chance to see and decide for themselves whether this is the kind of case that should have been brought. And they decided. And that's why in 10 days, President Trump is going to assume the office of the President of the United States. And certainly we're here for the court to sentence President Trump to an unconditional discharge. And for that, it's a very sad day.
Yeah, to be technical about it, it was not a majority, it was a plurality, but okay.
It's a sad day for President Trump and his family and friends, but it's also, in counsel's view, a sad day for this country because this was
because we elected a convicted felon. That's why it's sad. That's why I'm sad. It's because we decided as a country, you know what? I'm going to go with the felon. I think he's the guy.
Without a doubt, that was brought by a district attorney who promised that he would go after President Trump if elected and felt like he had to go through with that promise. And so that's sad. And I hope, and I know that President Trump shares this view, that this will never happen again in this country. And so we certainly understand where we are today. We very much intend on pursuing an appeal of this verdict and what happened during this investigation. And we certainly believe that the only appropriate sentence, if one's to be imposed at all, which we very much believe it shouldn't be, and that the case should be dismissed, is a sentence of an unconditional discharge. Thank you.
Thank you. Would your client like to be heard?
Yes, thank you, Your Honor. This has been a very terrible experience. I think it's been a tremendous setback for New York and the New York court system. This was a case that Alvin Bragg did not want to bring. He thought it was, from what I read and from what I hear, inappropriately handled before he got there. A gentleman from a law firm came in and acted as a district attorney, and that gentleman, from what I heard, was a criminal or almost criminal in what he did. It was very inappropriate. It was somebody involved.
Guys, he is sounding low energy these days, man. We are not getting, this is not 2016 Trump, okay? That is low energy. That's all I'm saying.
My political opponent, part of the records that we're talking about.
Mendez, thank you so much for 67 months. Fixer, did I get you for 125 months? I love you, buddy.
Well, the falsification of business records, as they said, was calling a legal expense in the books where everybody could see them, a legal expense. In other words, that legal fees or legal expense were put down as legal expense by...
Actually, this is the first time in history that people ever put bad numbers on their books. Because as we all know, people never they never cook the books. That's just not a thing that happens.
Accountants, they weren't put down by me. They were put down by accountants. I didn't call them construction, concrete work. I didn't call them electrical work. I didn't call them anything. They called a legal fee or a legal expense. And for this...
Yeah, it's literally in the name of the statute, falsifying business records. That's what the problem is, right? Yeah.
I got indicted. It's incredible, actually. Now, if you look, my attorney alluded to it, the top legal scholars and legal pundits in this country, the ones that are quoted all the time on television, that are making their views felt, and highly respected people, have said, everyone, virtually everyone that I know of.
Judge Merchan is a coward. This is not on him. Don't put this on him. This is on the American electorate. That's what's doing this. You can't blame him for this.
Haven't seen any to the contrary, not one. And none of these people are not exactly friends of mine, to put it mildly. But they all said this is a case that should have never been brought. It's an injustice of justice. Very respected Jonathan Turley, Andy McCarthy, Judge David Rifkin, a wonderful man who just passed away, by the way.
Any news on the TikTok stuff today? The Supreme Court heard the arguments, and I'm not really qualified to tell you like what way the wind is blowing on that one. I don't know. I don't know when they're expected to give their opinion. It was quite lengthy arguments. When I looked at the timestamp, it was like 2.5 hours, 3 hours. So, you can find it if you look up on C-SPAN, or if you just go on YouTube and search Supreme Court TikTok and then filter it to today in over 20 minutes, and you'll find,
Greg Jarrett, Ellie Honig from CNN, of all places. CNN said that. Paul Ingrassia, Alan Dershowitz, they all said this is not a case that should be brought. It's not, think about it, legal expenses are down as legal expenses, and I get indicted for business records. Everybody should be so accurate. It's been a political witch hunt. It was done to damage my reputation so that I'd lose the election, and obviously that didn't work. And the people of our country got to see this firsthand because they watched the case in your courtroom. They got to see this firsthand, and then they voted, and I won and got the largest number of votes by far of any Republican candidate in history, and won, as you know, all 7 swing states, won conclusively all 7 swing states, and won the popular vote by millions and millions of votes. And they've been watching your trial, so they understood it. I wasn't allowed to use the lawyer-client privilege or the reliance on counsel. I had a lawyer that made this deal, and he admitted that. And he was also a totally discredited person. We weren't allowed to use the information from the Southern District that totally discredited him. It wasn't allowed to be put in. And that was terrible, unbelievable. And this is a man who's got no standing. He's been disbarred on other matters, unrelated. And he was allowed to talk as though he were George Washington, but he's not George Washington. He shouldn't have been allowed. The Southern District did a book of approximately 28 pages where I've never seen anything like it. They excoriated him. You wouldn't let it be put into evidence. So he was able to testify.
Washington, true.
As a witness, and I think it's a disgrace to the system. I was under a gag order. I'm the first president in history that was under a gag order where I couldn't talk about aspects of the case that are very important. I guess I'm still under, so probably.
Well, you're the first president in history to be convicted of a crime, so I mean, that stands to reason, right?
Now, I assume I'm still under a gag order. But the fact is that I'm totally innocent. I did nothing wrong. They talk about business records, and the business records were.
If he hadn't been elected president, you guys, he would have gone to jail. It would have been jail time. His abject lack of any kind of acknowledgement of any wrongdoing, lack of any remorse, the fact that he violated his gag order so many times, the fact that there were 34 counts, it was gonna be jail. And this day would have gone a lot differently, but we don't live in that universe. In the infinite multiverse, we live in one of the universes where he got reelected. So
extremely accurately counted. I had nothing to do with them. Any of that was done by an accountant or bookkeeper who I think gave very credible testimony and was corroborated by everybody that was asked. And with all that's happening in our country today, with the city that's burning to the ground, one of our largest, most important cities burning to the ground, with wars that are uncontrollably going on, with all of the problems of inflation and attacks on countries and all of the horrible things that are going on. I got indicted over calling a legal expense a legal expense. It was called a legal expense. I just want to say I think it's an embarrassment to New York, and New York has a lot of problems, but this is a great embarrassment. I believe that this and other cases that were brought, as you know, the DOJ is very much involved in this case. It's because that's the political opponent they're talking about. The DOJ is very involved. You have a gentleman sitting right there from the DOJ who was from the DOJ's office. He was also involved with the New York State Attorney General's case. And he went from there to here. He went around and did what he had to do. He got them to move on me. But in the meantime, I won the election in a massive landslide. And the people of this country understand what's gone on. This has been a
Not massive, not a landslide.
weaponization of government. They call it lawfare. Never happened to any extent like this, but never happened.
I cannot wait to see how they govern with their landslide margins in Congress. I cannot wait, right? If it was a landslide, they have a mandate. They should be able to get whatever they need to get done. They should be able to get it done. I cannot wait to see how they govern with a 3-seat majority in the House. Have fun with that. Good luck.
In our country before, and I'd just like to explain that I was treated very, very unfairly, and I thank you very much.
Thank you, Mr. Trump. Mr. Trump, you appear before this court today to conclude this criminal proceeding by the imposition of sentence. Although I have taken the unusual step of informing you in advance of my inclinations, before imposing sentence, I believe it is important for you, as well as those observing these proceedings, to understand my reasoning for the sentence I am about to impose. The imposition of sentence is one of the most difficult and significant decisions that any criminal court judge is called upon to make. Our legislature sets the parameters for an authorized sentence, but it is a judge that must decide what constitutes a just conclusion to a verdict of guilty. The court is vested with broad discretion in determining what sources or evidence it may consider to arrive at an appropriate sentence. In doing so, the court must consider the facts of the case along with any aggravating or mitigating circumstances. In my time on the bench, I've been called upon to grapple with this weighty responsibility for countless defendants who have been found guilty after trial for an assortment of offenses, ranging from nonviolent Class E felonies to the most heinous of crimes, including homicides, sex trafficking, and child sexual abuse. The task is always difficult and deserving of careful consideration, whether the sentence be an unconditional discharge or incarceration of 25 years to life. However, never before has this court been presented with such a unique and remarkable set of circumstances. Indeed, it can be viewed fairly that this has been a truly extraordinary case.
That's one way to put it.
There was unprecedented media attention, public interest, and heightened security involving various agencies. And yet, the trial was a bit of a paradox because once the courtroom doors were closed, the trial itself was no more special, unique, or extraordinary than the other 32 criminal trials that took place in this courthouse at the same exact time.
Corby asks, did you see the video on Twitter of Trump talking about all the billionaires coming? I saw a caption of it. I didn't see the actual, but I do have that video queued up. I think that was during his press gaggle that he did after meeting with the various governors.
Jury selection was conducted. The same rules of evidence were followed. Opening statements were made. Witnesses called and cross-examined. Evidence presented, summations delivered. The same burden of proof was applied, and a jury made up of ordinary citizens delivered a verdict. And it was all conducted pursuant to the rules of procedure and guided by the law. Of course, part of what made it feel somewhat ordinary was the outstanding work, preparation, and professionalism of the clerks, court officers, court reporters, security personnel, and the entire staff of this building who did their jobs as they would with any other criminal trial. So while one can argue that the trial itself was in many respects somewhat ordinary, the same cannot be said about the circumstances surrounding this sentencing. And that is because of the office you once occupied and which you will soon occupy again. To be sure, it is the legal protections afforded to the office of the President of the United States that are extraordinary, not the occupant of the office. The legal protections, especially within the context of a criminal prosecution, afforded to the office of the President have been laid out by our founders, the Constitution, and most recently interpreted by the United States Supreme Court in the matter of Trump versus the United States, which was decided on July 1st, 2024. As with every other defendant in your position, it is my obligation to consider any and all aggravating and mitigating factors to inform my decision. Some of those aggravating factors have already been articulated in my Sandoval ruling at the start of this trial and by my recent written decisions on December 16th and January 3rd. Thus, they need not be repeated at this time. However, the considerable, indeed, extraordinary legal protections afforded by the office of the chief executive is a factor that overrides all others. To be clear, the protections afforded the office of the President are not a mitigating factor. They do not reduce the seriousness of the crime or justify its commission in any way. The protections are, however, a legal mandate which, pursuant to the rule of law, this court must respect and follow. However, despite the extraordinary breadth of those protections, one power they do not provide is the power to erase a jury verdict. It is clear from legal precedent, which until July 1st was scarce, that Donald Trump, the ordinary citizen, Donald Trump, the criminal defendant, would not be entitled to such considerable protections. I'm referring to protections that extend well beyond those afforded the average defendant who winds their way through the criminal justice system each day. No, ordinary citizens do not receive those legal protections. It is the office of the President that bestows those far-reaching protections to the office holder. And it was the citizenry of this nation that recently decided that you should once again receive the benefits of those protections, which include, among other things, the Supremacy Clause and presidential immunity.
Nothing is going to come from this, right? I mean, like, we'll put it on the same level as the impeachments. So he is an impeached president, forever will be an impeached president, but he was not convicted in the Senate. He was not prevented from taking office again. He is a convicted felon now, officially today. He will always be a convicted felon unless he gets it overturned on appeal, which seems unlikely. But he's not going to go to jail. So yeah, it's a unconditional dismissal. So there will be no penalty. The crime stays on the books, the conviction stays on the books, the label stays on the books, but no jail time. That's it.
It is through that lens and that reality that this court must determine a lawful sentence. After careful analysis, in obedience to governing mandates, and pursuant to the rule of law, this court has determined that the only lawful sentence that permits entry of a judgment of conviction without encroaching upon the highest office in the land is an unconditional discharge, which the New York State Legislature has determined is a lawful and permissible sentence for the crime of falsifying business records in the first degree. Therefore, at this time, I impose that sentence to cover all 34 counts. Sir, I wish you Godspeed as you assume your second term in office. Thank you.
There it is. And there it is. We can close the chapter on that one. Like they said, they're going to appeal. But that doesn't seem, I mean, who gives a fuck at this point, right?